Welcome back to The Narrative. I'm your storyteller, Callistra Farrier. Well, the conversation about what will happen in a legal sense to the three men who have been charged with capital murder in Grenada for the missing American couple whose yacht was hijacked back in February is now a conversation that's been happening. Whether or not the United States is going to try to get in on the action by way of extradition. I will be joined by RUGGLES Ferguson, senior lawyer, King's Counsel, and Grenada, to discuss what elements of the case may or may not allow the United States to make a case for extradition. Is that even a possibility based on the elements of the case as we know so far? And I'm also going to touch on the state of the judicial system in the OECS and particularly in Grenada. Dominica lawyers recently complaining, and the judge also there complaining at the end of their assizes that the judicial system is having a lot of challenges when it comes to the structure for the dispensation of justice. Welcome to the program, Mr. RUGGLES Ferguson.
Hi, good day, Callistra, and good day to your listeners and viewers.
All right, thank you
It's
so much
nice to
for
be back
joining.
on.
Yes, it's been a while. Thank you for coming on.
Indeed.
Um, we have had news reports in Grenada recently that the three men who have been charged, they're charged with capital murder, kidnapping, and a few other felony, very serious offenses that have been charged with, stemming from the disappearance of this American couple. But one of the parts of the conversation that's happening is whether or not they would be extradited. Some American outfit did talk about extradition in a way as if it was a done deal. But I want to ask you whether or not there are elements of the case that would even allow United States authorities to seek extradition to try them for any matter at all within the U.S. jurisdiction.
Yes, well, I have heard statements made of the possibility of the accused men being tried in the United States. But first and foremost, it will have to be based on their own special provisions of there. But even though you get them to the United States and they have to be tried based on evidence. And that evidence has already been gathered in these parts. They're already charged in Grenada, from what has been formally announced. So they have been charged with capital murder in Grenada. And the evidence, the investigation took place between the Vincentian authorities and the Grenadian authorities. So you have the evidence, actual evidence for the case being gathered, and the investigators being local. So even if you get individuals up to the United States, the question of a trial, and the evidential support for that trial will be an issue. I'm not saying it's insurmountable, but it certainly will require certain procedural steps to be taken, because first and foremost, there will be need for an extradition request first and foremost. And the alleged offenses were not committed in the United States or in some extraterritorial region where now, for example, somebody committed an offense in the United States and that person is now in Grenada. So everything really is in the United States. So you have many offenses where the charges have been laid in the United States, or the offense was committed in the United States, and therefore you want these individuals now to be sent to the United States for trial, and they are in Grenada. You make an extradition request. But in this case, the offense is committed elsewhere, allegedly committed elsewhere outside of the United States, and the investigation and charges have already been laid in a particular jurisdiction awaiting the start of the process. So it would not be the usual kind of extradition request. But in any event, even though that is done, then a formal extradition request would need to be made to the authorities here. It's normally done through the Minister of Foreign Affairs, who then, in his own deliberate judgment, will issue an authority to proceed. Let's say there is a position that, okay, we will follow up on the request and issue what is called an authority to proceed. And it eventually has to go before a court of committal, that's the magistrate, to make a determination judicially whether or not this request can be satisfied. And if the order of committal is made, then the procedure takes place. So there would need be a formal extradition request being made, because these accused are in the local jurisdiction. They are physically here. So one can't just take them and send them up to the
and
United
send them off
States.
to the United States. Not
Right,
as long as we
precisely. That
call
will be
ourselves as
other
sovereign
issues.
nation. Many other
Precisely.
issues, yes.
Yes.
But are there elements of the case, because you mentioned special provisions earlier on, are there any special provisions that the United States has? I know, for instance, when it comes to sex crimes, if you have committed an offense, a sexual offense in some other jurisdiction that is not even a U.S. territory, you can still be tried in the United States. But in this case, with Trevon Robertson, Atiba Stanislaus, and Ron Mitchell, the three accused men who have committed crimes within the jurisdiction of Grenada, have been charged in Grenada, is there any provision under American law, given that the couple are American citizens, that they can now use as a vehicle to try to get extradition? Is there any provisions at all exist? I know there was mention
Well,
of piracy because because of the stealing of the yacht and so, but is any of that does that have any legal basis?
well, I'm not aware of any provision that exists, and that doesn't mean that there is no provision existing. I'm not an expert on U.S. law. There may or may not be. But your reference earlier, for example, of trying individuals who may have been charged in other countries, first and foremost, these parties would usually be parties within the jurisdiction of the United States, because you can only try them in those circumstances if they are living in the United States, maybe citizens of the United States, they're living in the United States. The accused here are neither citizens, well, as far as I'm aware, of the United States. They are not living in the United States. They live in Grenada. The offenses were allegedly committed in Grenada. The Grenadian authorities have already charged them with these offenses, so they're already charged. So it's not a situation where people are at large and they are not charged yet. They committed a crime allegedly in another jurisdiction, and then a particular country wants to have them extradited. So I don't know of any formal request. I'm sure if any request was made, given the high profile nature of this matter, then that would be indicated as part of public information. So I don't know, sometimes, especially in the context of the US media, a lawyer might be speaking, and he may give a view as to what can be done, that they can be tried up there in his view, but there is no formal request or follow up, because the question of which is the most convenient forum to try them, then that would be an issue. So if you have all the evidence gathered in Grenada that is sufficient in the view of the prosecution to lay a charge against them, then what will happen to that? Are the Grenadian Grenadian investigators then will be required to travel to the United States of America to to give evidence, and that leads to all kind of new issues, new legal issues, and complications. So one has to really wait and see if really that this was just a statement made, not from official quarters, but certainly it makes interesting debate and discussion, certainly. But as far as I'm aware, there has been no formal extradition request, and you must have a formal extradition request in order to get the individuals back to the to the United States, because they were not living
Yeah,
there. One, and so you'll be sending Grenadian citizens for trial there in circumstances where not only you have the forum to try them, but you have the evidence, allegedly so, to support the charges against them, and they have no connection whatsoever with the United States.
because
So,
that media piece that I mentioned earlier on, what I found interesting about it is that the lawyer who was speaking made no reference to law in the United States that can be used to extradite them under the circumstances that existed. And they seem to be a bit unaware of Grenada as a sovereign territory with its own judicial system and capability to do this, and exactly what the facts of the case was. But what it did was that it stirred this conversation here and misled, I believe, my colleague members of the media in thinking that this can be done just like that. Because also, even if an extradition request is made, Grenada, as far as you know, in your experience as a lawyer, this is not something Grenada will roll over for. Even if the United States finds some um, piece of legislation somewhere on their books to ask for extradition, that Grenada would not send our citizens off to be tried on a matter where we have jurisdiction and evidence, and they are our citizens.
well, precisely, I don't,
It would be
I don't
challenged
expect.
in court.
Yes, there would need to be very compelling reasons expressed. It is the equivalent of a Grenadian being killed in the United States by an American citizen, allegedly, and we say we want to try the Grenadian citizen, the American citizen here in
Because
Grenada.
one of our
Bring
own
him back
victims.
because he has killed a Grenadian citizen. That in itself raises all kinds of issues in law, and that can prejudice the case itself. And that's why the issue of the most convenient forum, even though there may be other fora where you can try matters. So there's a branch of law called, private international law, that, addresses the issue of what is the most convenient forum. And if X is the most convenient forum, why should Y, which is not a as proper a convenient forum as X, why should they be sent to be tried there? So, those are the issues that arise in this matter. But as far as has been announced formally, the three individuals have been charged. They lived in Grenada. They escaped. They were brought back to Grenada, charged. The police in Grenada conducted their investigations, found that there was sufficient evidence in their view to charge them. So now they go through the due process of a trial, and possibly preliminary inquiry, because it usually starts at the preliminary inquiry stage, whether or not the attorneys representing them would opt for a Papercommittal instead of a full preliminary inquiry. These are issues yet to be determined, and will be determined by the proper representatives of the three accused.
I think one of the lawyers representing at least two of the men did say very early on at the arraignment that he would opt for paper committal. Of course, that is subject to the approval of his clients, but this is the strategy that he was hoping to move forward with, to have it go through the system as quickly as possible. But on
Right.
this, one of the issues that has also been raised coming out of this alleged crime that was committed is the issue of bail. I know that last year or sometime, both Ralph Gonsalves and Mia Mottley, prime ministers in the region, had come out against the judiciary, blaming them for the situation, giving them some of the blame for what's happening with crime in the region, and saying that, just the way that they handle matters is a cause. Now, your umbrella organizations had taken serious objection to those comments. But we see here the three men, at least two of them, being charged with serious crimes, getting bail, being out, and then going on a crime spree of rape and robbery, and culminating in what we now believe is a murder. Does that give you pause in any way? In an interview with the Director of Public Prosecution, say Christopher Nelson, he talked about the issue of how magistrates need to, I don't know, be a bit more wary in terms of the awarding bail to people, even where there's a presumption. But does that give you pause, this particular case?
Well, let me put it this way. Bail is a serious issue because it's always a balancing act. A magistrate or judge has to exercise a judicial discretion based on the material before him or her. And one cannot take an emotional approach to it. It's based on factors to be taken into consideration. And it's just important that the relevant information be there. You learn from all different experiences, but it does not necessarily mean that Peter pays for Paul and Paul pays for all. Because at the end of the day, when an application is made for bail, you follow certain principles of law to determine whether or not bail should or should not be granted. It's a serious exercise. And the starting point always is, one, there is a presumption of innocence. There is a presumption of innocence. So, and that is not a presumption that belongs to the prosecution or defense or the judicial officer. That's a presumption laid down in the supreme law of the land, the Constitution. Section 8 of our Constitution says in very clear terms, it provides, one, that when a person is charged with a criminal offense, then that person shall be afforded a fair trial within a reasonable time. It also goes on to say the person is entitled to a presumption of innocence, which stays unless the person pleads guilty, an accused pleads guilty. So until you are found guilty, not in the rum shop, but by a competent court, a court of law, or you have chosen to plead guilty, then you are clothed with the presumption of innocence. So that's a starting point. Now, when you are considering bail, the fact that an offense was committed before, or you are convicted of an offense like offenses before, that's a consideration that is taken into account. So it's all put into the mix. The difficulty is when and judicial officers must think differently. Judicial officers can't think just on an emotional level, because what will happen is that you'll find no bail for anybody. But those are factors to be taken into consideration, and what it means is that it's an adversarial system, that the prosecution will bring forward evidence to say, listen, this application for bail is not an application to be granted because of 1, 2, 3, 4, 5. The defense, on the other hand, would say it's an application that ought to be granted because of 5, 6, 7, 8, 9, 10. And the judicial officer then makes a determination. But that determination is based again on the context that there is a presumption of innocence. So now you have somebody who, there may be some obvious cases, but you have somebody who is charged for an offense. That person stays in prison for 8 years, 9 years, and then the person is acquitted. What happens? Right? And that's why due care and caution must be exercised. A bail application is serious because you have the interest of the public and you have, of course, the interest of the accused. And it's always a balancing exercise. It's not an easy exercise for a judicial officer, because one may say that something happens and then you blame the judicial officer and then go there and say, well, there shouldn't be bail for anybody. One cannot. That's a non-judicial approach to things. And while it might feed into a certain emotional constituency and say, well, listen, it sounds good for public consumption, but it's not the way that legal matters are treated. Because when it's bail, one of the factors you take into consideration, because bail is not determining whether the person is guilty or not. All that bail does is says, should the person be remanded to custody pending the hearing of this trial, or should he or she be released on bail pending the hearing of the trial? That's what bail is about. And when bail is granted, it is the judicial officer's satisfaction that that person will appear on the day and dates of his trial. There are guys who have been charged with serious offenses, and on more occasions than not, they're on bail, they always turn up to court. They always turn up to court. Another key question is, if these individuals or the accused is released on bail, is he going to interfere with witnesses? Is he going to obstruct the course of justice? All these are relevant questions asked. And there are conditions that you can set even when you grant bail. So at times people have to surrender their passports, or they have to sign in. Some people have to sign in, some once a week, some even up to 3 times a week, to make sure that you are in the jurisdiction, so that when your matter comes up, then you will be present at your trial, which is the key thing. It has nothing to do with innocence or guilt, and innocence or guilt cannot be determined before a trial.
Got you.
With due process.
This is The Narrative. I'm on with Ruggles Ferguson, King's Counsel. We're discussing a number of legal matters here on The Narrative. The conversation continues. When we come back, we will speak about the issue in Grenada, where the government is seeking to have people charged with gun possession not get bail. The issue of whether or not that is constitutional, given what the constitution of the country says, the supreme law, given what it says, and we'll continue the conversation in a moment.